What happens if a personal representative makes mistakes in administering an estate in the state of Florida? Well, the bottom line is if the personal representative is working with a competent attorney, they should not make the kind of mistakes that could lead to other beneficiaries or the court moving to have that personal representative be removed. One of the most important jobs as an attorney representative representing a personal representative is making sure you're real clear about what those duties are. We provide lots and lots of guidance, written information, lots of feedback back and forth, because the reality is it can be overwhelming. We do a lot of work at the front end to make sure that personal representative understands what the duties are, what their obligations are, so that they don't get into trouble. I don't want to get into trouble. And so helping that personal representative to understand very clearly what those duties and obligations are is a critical function of the attorney, who's being paid well, and the personal representative who's also being paid well pursuant to statute. The reality is we got to communicate early. We got to communicate often, the personal representative, what the duties are, what the obligations are, making sure that they understand that the word fiduciary is the role that the personal representative slips into. Oftentimes, personal representatives can get confused about what their duty and obligations are. They may try and take actions that represent self-interest. They may take actions which represent interests that benefit the estate and not take into full consideration that this fiduciary concept means that there are obligations to a whole range of parties. Those range of parties, thinking specifically about creditors. So, let's say that mom is aware of obligations that the estate has, that the deceased had to a business partner, creditor, something like that. Sometimes there's some conflict there where PR thinks, we're going to take advantage of this. We're going to ignore the creditor. That's not acceptable under Florida law. Under Florida law, the fiduciary concept, the personal representative has very specific rights, very specific obligations and duties. They must maintain those duties, and they must execute and discharge those duties in the full interests of the estate, that bigger picture concept of the estate, creditors, business partners, courts, other obligations that decedent has, and that oftentimes can set about conflict. So when you're involved in these situations, it's critically important that personal representative, heirs, creditors, everybody understands what the duties and obligations are. That's the role of attorneys. And when you see these big estates where attorneys are piling in, some for a personal representative, some for heirs, some for beneficiaries, some for creditors, that speaks to the complex nature of these kind of estates, particularly when we deal with lots of money and when there's other litigation involved. So if you're engaged in estate practice and it gets complicated, you need a litigator. Time to call in experienced attorneys. If you're personal representative, feeling a little out of sorts because things are getting complex, maybe time to walk away from that role, let somebody else jump in. If you are a beneficiary heir, don't believe that the estate's being managed properly because things just don't feel right. These are all circumstances in which it's time to ask for expert advice. If you have questions, drop it in here. We answer the questions on a rolling basis. That way you can just roll back and get the questions answered.